Welcome back to the Nichols Family Lawyers YouTube channel, where today I'll be talking about a very topical family law issue, the bank of mum and dad, where parents are gifting early property inheritances to their young children. I'm talking about something that's becoming increasingly common and increasingly complicated, early inheritances and the impact from a family law perspective. More and more parents are gifting property to their children now, rather than waiting until it's too late. With housing affordability at record lows, families are stepping in early to give their kids a leg up, and it's reshaping the property market, and we're seeing it more and more, particularly with the state of the economy. But before you do it, here's what you need to know. How you structure the gift matters, both legally and financially. There can be stamp duty and capital gains tax implications, and without the right legal protections in place, things can get really complicated, especially if your child later separates from a partner and is in a de facto relationship or is married. As family lawyers, we see these situations regularly. So today we're walking you through what you need to consider before gifting property or setting up an early inheritance for your children. So let's start with the basics. A gift is a voluntary transfer of money or property made without any expectation of repayment, no strings attached, no loan agreement. A loan, on the other hand, is money that is expected to be repaid, usually on agreed terms and sometimes with interest, and there should be a loan agreement in place. Simple enough in theory, but in practice, things get complicated very quickly, particularly when it comes to family. When the Federal Circuit and Family Court of Australia is determining When the Federal Circuit and Family Court of Australia is determining how to treat a payment from a parent to a child, it must consider something called the presumption of advancement. Put simply, when a parent transfers money to their child, the law presumes it was intended as a gift, not a loan. That presumption can, though, be overturned, but only if there is clear evidence that both parties intended the money to be repaid. And that's where so many families come unstuck. Because in the absence of any written agreement, any history of repayments, or any acknowledgement that the money was a loan, for example, a signed loan agreement, a court is likely to treat it as a gift. This is where the distinction becomes critical. If the money is treated as a gift, it becomes part of the asset pool available for division between the separating couple. It is not quarantined. It is not paid back. It is not on a balance sheet as a liability. It is simply factored into the overall distribution, which means the other party may benefit from the money that your parents gave you. If, however, the money is treated as a loan, it is recorded as a liability of the parties. It is noted on the party's balance sheet, just like a bank loan or a mortgage, and is required to be repaid, dollar for dollar, as part of the property settlement. That fundamentally changes the financial outcome. There are two key tools we recommend. So the first is a loan agreement. This is a straightforward document that records the lender's and borrower's details, the amount of money involved, the repayment terms, and what happens if repayments aren't made. Another example is if money is loaned for the purchase of a property. It may be that the loan agreement then also needs to have reference to, if that property is sold, what is to happen with the loan. Critically, it should be signed by all parties. A signed loan agreement is your strongest piece of evidence that the money was never intended to be a gift, and it should also be dated. The second option is a binding financial agreement, or as we call them, BFAs. A BFA is a legally binding document that can be entered into before, during, or at the end of a marriage or a de facto relationship. Where a family is provided or plans to continue providing significant financial support, a BFA can set out exactly how that money will be treated in the event that the parties separate. It removes uncertainty entirely. We're seeing parents buy investment properties outright for their children, give large sums in their 20s and 30s, and plan decades ahead to make sure their kids can get into the property market. There are significant sums of money, and the generosity behind them is real, but without proper legal documentation, all of the goodwill is at risk. The reality is, informal family arrangements and formal legal proceedings don't mix well. What feels like a private, trusted understanding can become a fiercely contested dispute before the Federal Circuit and Family Court of Australia, particularly when a child's relationship breaks down and a former partner makes a claim over assets that were always intended to stay in the family. So if your parents are helping you financially, whether it's $20,000 toward a deposit or $500,000 towards a deposit for a property, Get it in writing. The earlier the better. A simple loan agreement can now save enormous stress, cost, and conflict later. And if you're in a relationship where significant family money is involved, a binding financial agreement is worth serious consideration. At Nichols Family Lawyers, we advise and represent clients on all aspects of family law property matters, including property settlements, loan agreements, and binding financial agreements. If you're thinking about gifting money or setting up an early inheritance for your children, getting good advice early can protect everyone involved. Please contact our office on 9670-4122 to arrange an initial consultation. We'd love to help you do it the right way. And if you found this video helpful, please like, subscribe, and share it with someone who you think might need to hear it. We'll see you next time. I'm Nadine Udorovic, partner at Nichols Family Lawyers.